You're listening to Counsel That Cares, a podcast series brought to you by Holland & Knight's Healthcare and Life Sciences team. With more than 400 attorneys practicing across the healthcare industry, members of our Healthcare and Life Sciences team are on the leading edge of industry developments. This series serves as your personal checkup on the multifaceted playing field of healthcare law and business trends.
Well, this is another podcast edition of the Counsel That Cares. It's a podcast series brought to you by Holland & Knight's Healthcare and Life Sciences team. This is John Saran, a partner in the Healthcare Transactions Group, and I'm here with Rebecca Springer from PitchBook, a lead healthcare analyst.
Great to be here, John. Lots of exciting stuff going on in healthcare private equity regulation. So, let's dive in.
And I think it's good to note that we're actually live here at the Nashville Healthcare Sessions Conference. It's the third day, and what we're talking about today is actually a bill. While I think we're sitting in one of the sessions, listening to some great speakers, the legislature in Pennsylvania released an amended version of one of their state healthcare transaction laws that had been pending for several weeks, and it's notable because these laws have been the topic of a lot of discussions, especially with deal making for the rest of the year and looking ahead in 2025. There was and Rebecca, I'll ask you sort of the first question here. Why was, just to set the stage for why this Pennsylvania bill is important, what happened in the last few weeks in California that was sort of a monumental decision?
Yeah, so to rewind, California already has a healthcare review bill, has the OHCA agency. That bill went live, so to speak, in April. But there's a bill, California AB 3129, that the industry is tracking very closely that would have been very aggressive in its regulation of healthcare private equity transactions, giving the Attorney General essentially an up or down vote on any transaction. And you can fill in the details on that, John. But this, for the deal-making community, was a big deal, not only because California is a really big state. If you have a big platform, they probably have some sort of California presence, but because we've seen California be a leader in some of this state-level regulation. And so it was a key bellwether. And we got some big news. What was it now? About a week ago, Gavin Newsom vetoed the bill. Right,
and I remember that, and it's even come around Labor Day weekend when the California legislature passed the bill and it went to Governor Newsom's desk. I think it caught a lot of our clients, private equity sponsors, investment bankers, strategics, flat-footed, right? I think it was really a coin flip over the summer as to whether it would go or not go, and it was passed, and everyone's phone is ringing off the hook. We would be having a different discussion today if it had been signed. The veto cited redundancy. So as Rebecca mentioned, right, they just put in a law in April. OHCA has been working very hard reviewing a lot of transactions already. I think they have about 7 transactions that they've reviewed. And ultimately, the governor said, look, let them do their job. We'll see sort of what they find and then, kind of go from there. The bill also actually had some provisions that covered the corporate practice of medicine. I think you can apply the same redundancy standard to that. California has a very extensive corporate practice regime. It is actively enforced. There was a case in April where a court actually enforced corporate practice. So I think that redundancy theme could be applied to both sides of those bills. But I think it's important, sort of the reasoning, because as we look ahead, I think, right, this decision will affect, and we're seeing it in this Pennsylvania bill, right, other states and sort of how they consider what they need to do. States that, like Pennsylvania, that don't have a bill, it's a little bit different than other states that have bills, right? And we're looking to augment their frameworks. This year, there were 6 states total that tried to bulk up their laws, and all
that already had
laws,
review laws on the books.
Right, and they tried to increase the review thresholds or add certain private equity related provisions, and none of those bills passed. You mentioned Indiana did pass a reporting statute, but that was where the trend was going already. And then the California veto happened, and we're seeing the effects of it in this amended bill.
So I don't think a lot of folks in the deal community have been following Pennsylvania's sort of legislative journey on this as closely as California's, right? Like I'm not having conversations regularly with folks who are not attorneys about Pennsylvania. So maybe kind of break down what that Pennsylvania bill is and how it's been changed.
Sure. I mean, so actually Pennsylvania has been thinking about these laws for almost 2 years now. They tried last year and were unable to pass a statute. This year they had, there were 3 pending bills that covered different things or different sectors of the healthcare industry. And this one, the one that we're talking about, is HB 2344. And an amended version of the bill came online on Monday. And it focused only on healthcare facilities. So if you think about it, right, you have healthcare facilities, physician practices, there's pharma manufacturers, there's many different sectors, right, of parts of the healthcare industry. But this one focused only on healthcare facilities. So transactions between. So think of a hospital buying another hospital, or hospitals merging together, or a hospital integrating with ASCs. It was clear from this, right, rather than having a wide net capturing everything in Pennsylvania, they only wanted to look at healthcare facilities. And look, they have I think 5 voting days left until the November elections. They have until the end of November to pass it. We'll see where it goes. But that limited scope, in addition to a few other parameters that they changed, show, I think, the effects of the California veto. It shows the effects of industry participation on both sides, right? Not just against, but also for. And they also, I think, recognized some of the reasoning in Governor Newsom's veto, right? Give these agencies time to review the transactions, think about it, look at the trends, and make informed policy decisions. This bill actually has a 4-year sunset, so it automatically, right, will expire and unless the legislature reinstates it or goes in a different direction.
And that's a new feature of
That's a new feature.
Bills.
I mean, we haven't seen it in some of the other bills to date, and we also haven't seen a directive for the agency to complete a report. What did they find in their reviews? And that requirement is there after 3 years. So right before it expires, they have to submit a report showing the effects of it.
And presumably this was for the purposes of making the bill more bipartisan, more palatable to the business community. There's clearly some work being done there. And I think the narrower scope of this is interesting because, of course, the vast majority of private equity healthcare transactions, even within the provider category, are not facility-based. They're physician practice management and behavioral health and so on. So if they're targeting the sort of hospital skilled nursing set, that's a very narrow piece of this industry.
Yeah, I mean, private equity is not mentioned in the bill at all, right? So it's not even listed, right? So it's more of a general healthcare transaction review bill, which if you look at some of the early laws that came out in the space across the other states, they didn't mention private equity. That is more recent in terms of the focus, especially with the California AB 3129 and some of the other bills this summer that didn't pass. So this is sort of a return to just a more general focus on the industry.
Right, and we've had antitrust scrutiny of hospital mergers, I don't know, since time immemorial. So,
and just to say it, right, it's all healthcare facilities. So it's not just hospitals. Hospitals, obviously, right, there's a lot of news today, right, about hospitals out there, but it's all facilities. So think of ambulatory surgery centers, skilled nursing facilities, hospices. I think anything, right, that's like a brick and mortar that has a license is likely going to be picked up by this.
What other states should we be looking at? Oregon?
So, look, I mean, Oregon has had a set of laws that they've been implementing for 2 years now. I think they reviewed a dozen transactions. They're well underway in sort of what they've been doing. All their decisions are public, and we haven't seen a general trend where like they're only targeting certain players in the market. And look, they also recognized the need to look at this over an extended period of time. So with Oregon's framework, there's an initial review, then there's a 1-year follow-up, 3-year follow-up, and a 5-year follow-up. So they recognize, right, that you have to look at it over a significant period of time to see, right? Because initially there might not be effects, right, for that consolidation in the market, but then maybe in 3 years, right, it could. So they have a much more, I would say, much more streamlined framework that they've been implementing at this point.
And do you think that the bill that they looked at that was going to be fairly aggressive on regulating corporate practice and MSO structures is going to come back?
Yes. I think I think it's safe to say that it will be sort of back on the docket next year. I know the industry is participating in that as well, on both sides of it. I think it'll be interesting to see, not just with that bill, but with other similar bills, right, that come up in 25. Do folks take a hard look at the Governor Newsom's veto and say, is this redundant, right? Just using Oregon as an example, they have corporate practice. They have statutes, at least on the dental side, that expressly say what a management company can or can't do. Why do you need more, right? I think that's the basic question that I think folks need to ask and be able to answer if they want to proceed with these types of legislation, looking at what happened in California.
So you really see California as a signpost that there may be a shift in how states are thinking about these laws?
I think it's a fair question, right? OHA is reviewing transactions involving physician practices and dental practices, and they're looking at them over a 5-year period, right? So you could apply the same logic, right? Let OHA do its job in reviewing those transactions. They are aware of the narratives out there regarding private equity. They are aware of the narratives out there, and they say it in their documents, for DSOs and MSOs. So they are looking at the data already. Why is, essentially that's the question, why is more needed?
Be interesting to talk about what we think the effect is going to be on deal activity, deal sentiment, right? Zooming out for a second, the increased media scrutiny, headline risk, and then regulatory risk around provider transactions has taken some of the bigger firms out of the direct care provision market, right? So I think there have been trickle-down effects. If California had gone through, I think you would have probably seen a rush of deals trying to get across the finish line by January, but that's not the case now. What else are you thinking about in terms of where deal sentiment is headed on the back of some of these decisions?
So I think the outlook for next year is definitely more positive now, right? I mean, I think I was thinking about this in a month ago, right? I think even before, the rates came down, there was uncertainty regarding them.
We were already starting to accelerate about midpoint this year.
Yeah. So in a course of a few weeks, I think the outlook changed positively. And my hope with what we're seeing here in Pennsylvania and sort of recognition by the states of not implementing broad, sweeping antitrust reviews on transactions, right? Not hopefully, but I think it sort of validates some of the things that I was saying coming out of the veto, that it's going to be harder for these states to pass those types of legislations, which should bring down, I think, the temperature and some of the anxiety and fears on these types of laws. And that's the thing. These laws drop, and sometimes there's a reaction of fear and anxiety, like the unknown, right? They don't know what these are. These agencies are going to stop our transactions because they don't like us, right? We spoke, there was a panel yesterday with the FTC, and they said, look, there's no secret plan out there to kind of stop these deals, right? We have very well-known parameters that are out there. Follow those parameters and you will get your deal done. And they quoted yesterday, right, only 1% of transactions are actually sort of snagged up. And I think the same goes with the states. I think there's only been one across all the states that have been reviewing these transactions, national transactions, and there's only been one or two transactions that hit roadblocks, significant roadblocks, and there were unique reasons for that. So, look, there's a path ahead here. I know it took some time for folks in the industry. I mean, Holland and I, we've been on top of this. Like, we have a practice. We know how to grapple with these laws. But it took some time for folks to become aware of this, understand how to navigate them. But we'll still be able to get deals done.
Yeah, we are right now, right?
Yeah.
And I think, look, like rewinding back to, was it March when the tri-agency request for information was put out, and some of the rhetoric in the documentation that they put out was fairly strong, and then you had things, going on in California, and you didn't know whether it's going to be a domino effect. From the deal maker's perspective, you can see why there was a lot of trepidation, but it sounds like we're kind of settling into a place of being able to move forward. These are sort of controllable risks. You sort of do your diligence, put in your paperwork, and move forward.
I think in multiple panels we heard today involving current and former federal officials, they all said that those RFIs and those types of requests for information are meant to actually gather information, right? If they wanted to, they have the tool, as they said, they have the tools necessary to subpoena and get the critical information, right, that could sink your organization if they wanted to. But this is actually like a genuine request for information. But I understand that sort of that concern is out there, and they actually addressed it in this Pennsylvania amended bill. One of the provisions that was added in this latest version said any information that you submit to the AG cannot, for purposes of reviewing a transaction, for reporting a transaction, cannot be used for prosecution for other sort of unrelated
That's interesting.
Reasons. Because that was, and that's been, I've heard a lot of folks out there make those statements. You have these wide nets, you're collecting all this information, right? An agency could then pass it off to a medical board or a dental board or another enforcement agency, right? And then that could be used for some other enforcement action. And I think they recognize that those concerns are out there, and they put that directly in the bill.
Really interesting. Well, and the sentiment, I think, at this conference has been a lot more positive than, I don't know, like last year, JP Morgan, the mood was pretty grim, right? So it'll be interesting to see what next year holds.
Yeah, but I think we can be sure that there will be more of these state laws. I think they're going to be a lot more limited, and there's going to be, I think, participation from the industry on both sides. I think the California AB 3129 really increased that across the board. I hadn't seen it for the other states. There's already some states like Indiana thinking of potentially adding to their framework. Some of the candidates for governor put out a health plan covering that. So there could be, copycat states for AB 3129, but it didn't pass, right? So they would be sort of going out.
So you think the sort of pre-deal review process is something that may spread to additional states?
For private equity backed transactions. But I think it's going to be a lot harder to get support for that with California not proceeding down that path.
Interesting.
Because it seems like the states are returning to more of that sort of more, comprehensive look at the industry, not just focusing on private equity, right? I think you told me the other day it's only 4% of, right?
Right. So less than 4%. So the proportion of healthcare providers in the U.S. that are private equity backed by revenue, we estimate it at 3.3%.
Right. So why make sweeping policy, right, that potentially could burden you have limited resources, right? Why do that? So it'll be interesting. Yeah. Well, I just want to thank you for joining me, and it'll be interesting to see where this all goes. But I think you can see. Like I said, I think you can really see in this bill sort of the effects of the broader trends, which is great.
Yeah.
Hopefully we'll be talking soon. We'll certainly keep you in mind when the next state comes down the pipe. But I think good things are ahead.
Yeah, appreciate your detailed perspective on this, and there's a lot to keep track of across all these different state processes, and it's helpful to understand some of the nuance here and where we might be headed going forward.
Great. Well, thank you, Rebecca.
All right, thanks.
Thank you for listening to Counsel That Cares. For more information on Holland & Knight's Healthcare and Life Sciences team, please visit hklaw.com/healthcare.